The panel, which is not denominated as a Yates Memorandum panel, we're going to do that. We're also going to tackle the Sessions memo, and given the last panel discussion, maybe we should start with that, because there is a relationship between charging decisions, and particularly in white-collar cases, but in other kinds of cases, and the Yates Memorandum, because individual responsibility and getting corporate cooperation in an internal investigation often requires that employees have some incentive to cooperate with corporate investigators or the government. The government has obviously tools to compel evidence, but companies do not, and they require effective compliance programs, the ability to threaten the employment of those who work for the business to gain cooperation in an internal review. But how the government views charging decisions has an impact, particularly when it relates to individual culpability and sentencing. And so in the wake of the issuance of the Sessions memo, we just heard from a great panel of U.S. attorneys. Not all U.S. attorneys have interpreted the Sessions memo as not a change in policy. And so one good example of that would be the Middle District of Florida. And I want to talk about this because, one, Sandy experienced this interpretation when it came out on May 16, 2017, when the U.S. Attorney in the Middle District of Florida announced that the office had received and digested the Sessions memo, that plea offers that had been extended in cases would be valid and respected until May 31. 2017, at which point, and unless there was an earlier deadline that had been given by the Assistant U.S. Attorney, and that after May 31, those plea offers were no longer valid, and that for existing cases that were not resolved, the office reserved the right to supersede charges that had already been returned to comply with the Sessions policy. And so Sandy, in his role as chair of the criminal justice section, has been working on this issue with the ABA. And Sandy, maybe you should give us an update on what the ABA is doing.
And Tampa, since, fortunate or unfortunate, I guess from a hurricane perspective, but from a DOJ perspective, we're in the Middle District of Florida. So just to start, the way we really, on May 10th of this year, Sessions issued his memo. On May 16th of this year, every defense lawyer in the Middle District of Florida that had a pending case or investigation got a letter from the, we don't have a nominated U.S. attorney, we have an acting U.S. attorney, which essentially said, I mean, this is my paraphrase, there's a new sheriff in town. Things are changing, I'll give you 2 weeks. In the next 2 weeks, you can plead to whatever great deal you can figure out, but after that, it's a whole different ballgame. And he didn't say it just applied to drug cases. I mean, it was every case, every fraud case, every case. And so when I got I knew about the Sessions memo pretty much when it came out. I was really concerned, and from an ABA perspective, and I knew I was going to be the incoming chair, I asked if we could convene a task force quickly, because we had the ABA convention coming up in August, and we have our counsel for the criminal justice section, and we consider resolutions, stuff like that. So I convened a task force to take a look at this and see if there was some resolution that could be considered for criminal justice policy and ultimately ABA policy. And that task force was tremendous, and they looked at, they pretty much looked at pretty much what you heard. Every policy as it started in the early 80s, as through, up to Ashcroft, and then, Larry Thompson, then ultimately Holder, and now Sessions. And our conclusion is that this was really a significant change. it's a big deal, we believe. And so from the criminal justice section perspective, we passed a resolution calling for the rescission of the policy. We are having ongoing discussions with DOJ, really along the lines of what I asked in my question, which was, how's this getting implemented? What does it mean? The policy says, the letter says that it's utmost importance to enforce the law fairly and consistently, which means, you know, the policy ought to be the same in the Middle District of Florida as it is in New York City or whatever, or North Carolina. But you heard up here, there really was a different view. I mean, John Horn from Atlanta said he didn't see much change. Well, just from a drug perspective, there's a huge change, because we had Holder, under the Holder years, we had this Smart on Crime initiative, you know, which led to President Obama's clemency, you know, the clemency project that many folks here, even though I never did a drug case, you know, on 2 white-collar cases, many of us participated in that process and got clemency for folks that, you know, were essentially nonviolent offenders that ended up with these ridiculous mandatory minimums. And there were a couple of Holder memos that had to do with charging, had to do with you know, enhancing charges with these 851s, had to do with priors or the 924Cs or you know, using it to get a plea, you know, that if you plead, we'll not enhance, or we'll only enhance once. So that's a big deal. And as far as I can tell, there is nothing in place to determine, you know, that there is some consistency in the way that this is being applied. In a very large case that I have, it was applied in a white-collar case, you know, which is essentially this letter from the U.S. Attorney, which if you don't plead now, you'll never get as good a deal as you were before, because the new requirement is that you should, and this is the language, you should charge and pursue the most serious, readily provable offense. Okay, we've seen language like that before, but it goes on and says, this policy utilizes the tools Congress has given us. By definition, the most serious offense, that's the language, are those that carry the most substantial guideline sentence, including mandatory minimum sentences. So, and then the next paragraph talks about there will be circumstances, and it would suggest rare circumstances, where, you know, good judgment would lead a prosecutor to conclude that the strict application is not is not applicable. But it's certainly, there's no suggestion in here that you know, that in the typical case that there would be discretion, you know, to not pursue the most readily serious provable offense, which would include the one that carries the most substantial guidelines, which would have significant consequences in white-collar cases. And, you know, if you marry that up with Sally Yates' memo, you know, and the guidelines that have been codified basically in the U.S. Attorney's Manual, you know, where at least in corporate fraud cases, the instructions are to seek, you know, seek prosecution, civil and criminal, you know, against individuals. You know, one has to wonder, you know, where are we going to be with this administration? So, you know, from the panel, I didn't get any sense that anyone really knows, but I think it's a real concern out there.
So what is the criminal justice section doing?
So what the criminal justice section is doing is we've passed a resolution seeking the rescission. The ABA hasn't considered it yet. It may become ABA policy, but meanwhile, as a result of the resolution, Justice has asked that we meet. And so next Friday, I'm going up and meeting with some fairly high-ranking people in Justice to begin to discuss it at least. You know, and one of my questions is going to be, how are you implementing this? What are you doing to make sure? I mean, what does it mean? Does it really mean that when you rescind, you know, on criminal justice section, it's not just interested in white collar, but does it really mean that you know, every time you can enhance a drug case, you're going to do it to seek a mandatory minimum? Is that what you mean? Or does it mean something else? What have you told the U.S. attorneys? And we'll see what the answers are. We're going to encourage them that this is not a good policy. It is, in my view, stripping discretion out of the process, not putting it into the process. And we hope that, through some dialogue, we can get some sense of what's going on. I mean, Jack Selden is part of this, group, and, hopefully we'll make some progress, Jack.
And so the policy of the criminal justice section, at least, or the sentiment of it as expressed by the CJS is the Sessions memo should be withdrawn.
We passed a resolution, the council passed a resolution asking DOJ to rescind the, I mean, if it doesn't really change anything, then why do we do it?
Yeah, but I was going to ask you to sort of weigh in, because you saw the change in the practice of your AUSAs when you were U.S. attorney.
So as a Holder administration U.S. attorney, when the Holder memo came out, it was a big change inside offices, because there was discretion. This is the way that we read it, that discretion was given to AUSAs in the field to make decisions about cases and about defendants by the people who are closest to the case and the defendant, the AUSA. And so, and then there were, as Sandy said, additional criteria for when you should enhance. So the default was, let's look at these individuals and what is the, what is the appropriate sentence or punishment that this person should have. And again, it was coupled with clemency initiative, so that it was a purposeful policy to reduce the number of people in federal prison, reduce the number of cases. So, and the other panel also talked about the number of cases has gone down or went down during the Holder years, which was by design. So it was not a numbers game. In fact, by design, during those years, the idea was to bring fewer cases, bigger cases, more substantial cases, and not play we did more of these this year than we did last year, thus we must be better at it. So, so when the Sessions memo came out that says we're giving more discretion, you can't do this, it seemed upside down to me as the leader of the office during the Holder years. The default is now you have to charge these extra things, and in order not to, you have to get supervisory approval. That is the opposite of discretion. So, so my point of view is like Sandy's, is that I think there's less discretion, and it is not tied to violent crimes and drugs. So we really do have to wait and see office by office whether, how wide the Tampa response is really unusual, especially in light of the panel of U.S. attorneys who sat up here and said there's no change in my office. So that is cause to be worried.
So with that, we'll move to the Yates memorandum, but if any of you have feedback for Sandy or Jack, who are going to go up and visit the department from your individual cases or in the districts where you practice, I'm sure both of them would be happy to take your input so that they could integrate that into their discussions.
Well, because it's just starting. I mean, it was just a memo that was issued on May 10th. That's not very long ago.
Right. So with that, we turn to the 2-year review of Sally Yates' policy, is one of my 2 fired by the president friends. The other one's taller. That's the only other hint I'm going to get. The Yates memo, which has been discussed in many white collar programs, and we now have a little bit more runtime with the policy than people had when they started talking about it after it was first announced. If you go back and look at the language that Sally used when she announced the individual accountability policy, which would be the formal name of this policy, which, as Sandy mentioned, has now been integrated into the U.S. Attorney's Manual. And if you read the original memorandum and Sally's speech to New York University Law School when she announced the policy on September 10 in the speech, and it came out on the 9th of September in 2015, you'll see that the language that she used is actually kind of a rebuttal to a series of criticisms Judge Jed Rakoff had written about in the January 9, 2014 issue of the New York Review of Books. Judge Rakoff was, first of all, as a judge, he couldn't really take a position of whether there were actually any crimes in the 2007-2008 financial crisis. So the article's funny from that perspective because he goes, first of all, I'm not saying that there were actually any crimes. However, if the Great Recession was caused in material part by intentional fraud, quote, the failure to prosecute those responsible must be judged one of the more egregious failures of the criminal justice system in many years. And he ticked off sort of what he described, if there had been fraud, were some of the great failings of the failure to hold individuals accountable after the financial crisis in the late 2000s. The difficulty of proving fraudulent intent in the ranks of top management, several levels removed from those putting together collateralized debt obligations. The problems with proving materiality or reliance when the counterparty to a transaction was also sophisticated. And that it would be harmful to the economy to prosecute individuals in these important companies and institutions.
Maybe too big to fail?
Too big to jail.
Too big to jail.
Right.
Yeah.
And so it is, if you then read Sally's speech to the students at New York University, she said really sort of that the new policy is designed to address those very kinds of concerns. Specifically, she said, quote, we cannot allow the flesh and blood people responsible for misconduct to walk away while leaving only the corporation's employees and shareholders to pay the price. It is the only way to truly deter corporate wrongdoing. And so with that premise, the Yates memo, which most are familiar with, but I'll just sort of tick off as the critical components of the Yates Memorandum revolve around 6 core principles. That in order for a corporation to receive credit for cooperation, it must identify all individuals involved in or responsible for the misconduct, regardless of their position, status, or seniority, and provide all relevant facts about the individuals involved in the misconduct. Second, that the criminal and civil assistant U.S. attorneys are urged to focus on individuals at the very onset of an investigation. Third, that those personnel in both the criminal division and civil division are to coordinate and communicate with one another, sharing information during the investigative process. That in the absence of extraordinary circumstances or when already consistent with a pre-existing policy on leniency, such as the antitrust division's corporate leniency policy, corporate resolutions will not provide protection from criminal or civil liability for individuals. The fifth, that civil and criminal enforcement actions involving corporations should not be resolved without a plan to address individual responsibility within applicable statutes of limitations, and that any declinations must be memorialized. And finally, that civil division attorneys should consistently focus on individuals as well as the company and evaluate whether or not individuals should be sued, even if based on considerations beyond the individual's ability to pay, suing people even if the government knows that they may not be able to collect. And those were the sort of core principles of the Yates Memorandum. So in doing our homework, we sent Ann on a mission to speak to the person whose name the Yates Memorandum bears, to first of all to get sort of Sally's take on how the policy has worked in practice, and Ann, in your experience as United States Attorney when this policy was announced, you can talk a little bit about how you think it's gone in the 2 years since.
I did hunt down Sally Yates and had dinner with her last week to tell her that I'm on this panel and I need some intel. So I'll get to that in a minute. But I'll tell you this, that actually had left the department right before the Yates memo came out. Sally and I talked about it about the week before it came out. She previewed, hey, I'm going to do this thing. I don't think it's that big of a deal, but let me run a few things by you. I thought it was a bigger deal than she did at the time, but she was also quite shocked with the number of law firm memos that came out afterwards. So the whole avalanche of Yates' responses was shocking to her. So it is, I think, enlightening to know that when it was decided to do the Yates memo, or to do a memo, that it wasn't designed to be this massive, huge change in policy. In fact, a lot of what Mitch just read out is really directed internally into the Department of Justice. Hey, AUSAs, hey, people who are doing these cases, coordinate with each other, talk with each other, focus on individuals. This is how you should be looking at corporate fraud cases. It was in fact a response to not necessarily Judge Rakoff, but it was definitely a response to the perceived failures of the Department of Justice in the financial crisis not to bring cases against individuals. So part of it was to instill confidence in the Justice Department and in the ability to bring cases and to have a focused corporate fraud strategy. And then the other part of it was, I think, things that Sally has held dear to her as a 28-year veteran of the Department of Justice. And part of that, I heard Sally speak on a panel in 2004 or 2005 where she talked about some of these same concepts. So this is sort of how she's wired, or was wired as a prosecutor. And I believe that part of it was Sally's belief, and others, that both defense attorneys and AUSAs, or fraud section people, had fallen into a complacency in the way that these cases were being done. That there was a formula, we're going to do an internal investigation, we're going to identify the number of the check, we're going to identify the people who are going to get fired, we're going to sign it and move on to the next case. And I think Sally wanted to, via this mechanism, to sort of shake up the idea that that formula is broken and we need to refocus on a fundamental part of the Department of Justice, and that is to identify culpable people and put them in jail or do whatever is appropriate to do. So that was, I think, the intent going in. And we discussed, I thought that the two biggest deals were the civil liability section and the all or nothing cooperation deal. And I think to some extent that sort of panned out that way, that those were the two big changes. So after it came out and the whole avalanche of the skies falling memos came out, and I wrote one of them too. How many wrote a Yates memo? Yeah, we all did. You guys who didn't move, you just don't want to admit it. So I talked to Sally a couple of months later, and she thought, wow, people are really misunderstanding this. Should I say something more? And I said, yes, you should. If you think that this thing is being misperceived, get out there again, and not to do Yates 2, but to speak about it formally, which she did. And a couple of months afterwards, she made another speech, and she said, the goal is not to increase the number of individuals who are going to be prosecuted. That's always been a goal. The goal is to institutionalize the process, the mechanism by which corporate fraud cases are investigated and prosecuted. There's a big, for anybody who's ever been in the department, especially in Washington, there's always this paranoia about how cases are being done from district to district and how different that's being done. And that's why 2 months later, it was codified in the U.S. Attorney's Manual. This is how we are going to do this. This is the Bible. We want consistency in process across the country. So this is going into the U.S. Attorney's Manual. And again, some of this is internal. Look at individuals from the start. We're going to do that. We're going to go after individuals civilly. And her other big soapbox issue is voluntary disclosure. I heard Sally speak 15 years ago to tell companies, if you voluntarily disclose, we will treat you differently. We will treat you better. We will embrace the fact that you've identified fraud and come to us with the fraud. Of course, everybody goes, yeah, right. That may be what Sally Yates does, but that's not how it works in my district. But that's always been a Sally Yates goal, and that, I think, has remained the case. So to the extent that that folks thought, oh, there's going to be this is going to cause the system to crash. We're going to have so many trials. There's going to be a lack of cooperation by companies. Individuals are going to be, and there have been a lot more individual. That has actually stuck. But Sally never believed it to be true, and I think the panel before us also sort of solidified that is not true. So, and then finally, last week's tidbit, she looks fabulous, by the way. Well rested, good hair, all the things that are important. And so I said, hey, what do you think is going to happen in the sessions department with the Yates memo? And other than the fact that they will never call it the Yates memo,
Right.
because that's like Voldemort. So it's the memo whose name shall not be spoken. But she said nothing, because she said nothing will happen. Nothing should happen in the sessions administration to the memo, because this is a bedrock idea of the Department of Justice, has been forever. We find individuals who are guilty of wrongdoing, and we punish them. And so that's the bedrock formula of the Yates memo, and that should not change. And we encourage voluntary disclosures of bad conduct, not just in fraud, but in FCPA and in SEC and other areas of regulated industries. And we are in lockstep that you should be looking for bad conduct and come to us and be treated more favorably if you do so.
And I'll tell you, as a forensic investigator who has, matters in front of the Department of Justice, that the most pushback that we get on the work plan on the investigation comes around, have we done enough to run down to ground culpability, especially if there's evidence of wrongdoing. So there's sort of that healthy, back and forth of whether more can be done. So I can give you a quick example of just a recent conversation that we had. This is an FCPA matter. It's a U.S. company, subsidiary. One subsidiary happens to be in the Middle East. The highest ranking individual in that subsidiary, the country manager, was purposely circumventing the controls of the company. What she was doing is breaking down the purchase orders, so that was all underneath her level of authority, her signing authority, and she was doing this in tranches so that her purchase orders would not elevate to her superior who sat outside of the country. And what she was doing was using a handful of vendors to among other things, revenue recognition, round-trip transactions, and a way of funneling money to government agencies and government officials for various nefarious reasons. And what we, as part of the investigation plan early on, of course, trying to run down these allegations and determine who was involved and how high up did it go. Did it go outside of this particular country or not? So the typical things like email review, right? ESI, very targeted interviews, asking questions, and looking at accounting documents, including the POs, which we could clearly see there was a pattern to hide her behavior from her bosses. As we were updating the Department of Justice on our work steps and on our findings and our interview that we had with the country manager, and by the way, the country manager in the interview admitted and conceded to certain schemes, not all of them, but quite a few, because the emails were just overwhelming of her involvement. And as we were updating the DOJ and doing a readout of the interview memo and telling her that we saw nothing in the ESI that indicated that her superiors knew or people out of the country knew, no interviewee mentioned once that others outside of the country knew, and we could see from the accounting records it was hidden. The response from the DOJ in this particular matter was, after that particular interview where she conceded, where she admitted to the wrongdoing, did you review her cell phone records for calls that evening after the interview to see who she called?
Wow.
Which, was pretty silent in the room. Kind of all looked around and said, no, we didn't do that. So this was a matter, this is under the pilot program. It's full cooperation by the company. The DOJ asked us to do this, and we did. We pulled the cell phone records, which were the company records. And actually, we did see her make quite a few phone calls to individuals within the country who we already knew were involved in the scheme. But luckily and thankfully for the company, there were none outside of the country.
So the question that comes to mind, whose responsibility is it to investigate criminal conduct? Is it the company's responsibility or the government's? And, what's happened is that, and not just the Yates memo, it started with the sentencing guidelines for corporations and all, and, what really constitutes cooperation for purposes of getting credit on the guidelines. But what's happened is that, a number of now bigger firms, Zuckerman Spader is probably not big enough to get hired to do any more, to do an internal investigation, VW or whatever, and there's 40, 50, 100 lawyers. Hank can tell us how many get put on these cases. But the lawyers become junior FBI agents basically, and the consultants. And what they end up doing is, conducting an investigation, try to, and in the old days there would be joint defense agreements, where people would there'd be cooperation amongst counsel for the corporation and the individuals, and the fruits of an interrogation, I'll call it an interrogation like the one you indicated, if that woman had a lawyer, that would have been protected, by a joint defense privilege. There's no joint defense privileges anymore that apply, at least in public company internal investigations. It's just not, it just doesn't happen. So, I do think that, there has been, some impact from a combination of corporate sentencing guidelines and the Yates memo on the criminal side, and then on the civil side, there's been, I think, a really huge impact. Individuals, people that I represent now, executives, they don't get releases anymore in corporate resolutions. And, almost traditionally, if there was a corporate resolution on the civil side, even if it didn't resolve the criminal stuff, there would always be a release for the individuals. And now there's no releases anymore. And, to hear that Sally Yates, it didn't make any difference to her that, that some guy could end up with some multi-million-dollar judgment and starting out, not having any money. To me, that's sick. But, that's, I guess, another story.
Yeah, so I want to talk about healthcare in a minute, because I think that is an area that where the Yates memo's full impact has been felt, because you have such agency support for it. So then there are many administrative tools that can be coordinated with the department in those cases. But Ron, before I leave the point that you made, which was about internal review, the individual accountability policy offers significant benefits for the company's cooperation and identification of all relevant facts and culpable people, so that early identification of an issue that either, you mentioned the pilot program, where the government's not aware of the problem, so you can truly self-report, and it's a true voluntary disclosure of information of which the Justice Department was unaware. Or even in the context of an investigation where you can identify culpable individuals or wrongdoing early, because the government has said in the Yates Memorandum that its investigation, of course, would proceed in parallel. There's a premium on it. There's a real benefit to the company to try to get to the bottom of it as soon as possible. And we'll talk a little bit about Sandy's point about why that makes joint defense agreements harder than they used to traditionally be. But tell me a little bit about, Ron, your experience and the tools that you use in order to try to identify these things on the front end.
Well, for the culpability standpoint is our good friend ESI, right? Our good friend email reviews really does reveal quite a lot of good information. You definitely have situations where we had a few investigations where conversations were taken offline off the company email server using WhatsApp and other types of communication, social media, things like that. And social media is another perfect example of information. There's tools and technology that scour social media, looks for chatter, looks for relationships among individuals, especially in corruption type cases, ones that aren't so obvious. and certainly in very targeted interviews as well. Well, I can tell you, a lot of our clients are doing more work on the proactive side. So, for example, using data analytics to really scour their databases to look for anomalies. So let me just give you a couple of really quick examples. I mentioned to you that this particular country manager was purposely going out of her way to break out POs and break them all under her authority limit. I mean, there are analysis that companies, should be doing and are doing proactively to look for this type of behavior and this type of circumvention of controls, which could indicate that you have a problem early on. Another perfect example, I think, especially after Wells Fargo, a lot of financial institutions, a lot of insurance companies are looking at their own sales data to see if there's all these add-on products being sold and if there's legitimate reasons or if they're seeing any anomalies in the data. We had a client a few years ago. It was an issuer of subprime credit card and had very aggressive sales tactics, including selling its cardholders different products like AAA auto coverage and subprime credit cards that most of these cardholders didn't even own automobiles. So all this is in the data if people were looking for it. So I think a lot of companies are doing a better job, and there's still more room for improvement, of proactively mining their data to look for anomalies and issues early on as opposed to late in the game.
So if you were to take a look, the reason in the paper that you have on this topic, I took the automobile industry first, is because if you look at the GM settlement, which was in the works before the individual accountability policy was formally announced and actually was resolved days after it was officially distributed. The General Motors case involved a $900 million recovery. The essence of that case was that GM had deceived the National Highway Traffic Safety Administration with respect to a defective switch, which caused or could cause airbags not to deploy. No individuals charged. Compare that case with the Takata airbag case. Right? So there you have a $1 billion corporate resolution of criminal charges. There, the issue involved a propellant that the company used, which caused airbags to rupture and cause injury or worse to passengers. 3 corporate executives charged in the Takata case after the Yates memorandum was formally implemented. Or Volkswagen, another case in that space, with a $4.5 billion corporate fine, and 6 individual officers that were charged in that case. However, of the 3 Takata officers and the 6 Volkswagen officers, I think only the guy that got caught in Miami at the airport is the only one apprehended and actually brought before a U.S. court to date. I don't know whether the department has issued a bunch of red notices through Interpol and made these indicted persons' lives more difficult, but as they've done in other white-collar cases. But at least the intention to charge responsible corporate officers was there, and in the press release related to the Volkswagen resolution, it specifically enumerates why those people were charged, what positions they held, what role they played in connection with the case.
That comports with the last panel, and I think it was Jill Rose who said, the individuals are being looked at with a lot more intensity. And the GM case is a good example. That was, I think, a good example of the old school way of resolving a big corporate case. What's the amount of money? Who's going to get fired? Let's sign on the dotted line and we'll move on. And that's probably the end of an era, I believe.
Yeah. Sandy, it makes sense to talk a little bit about healthcare because of all of the areas of white-collar enforcement. I think the Yates Memorandum has had its biggest impact in healthcare for a couple of reasons, because the coordination between the department and the Department of Health and Human Services, because of HHS's own ability to exclude and suspend people from participating in programs, to impose their own monetary penalties, it seems like, and the fact, as you mentioned, that False Claims Act cases routinely carried with it a release of individuals, officers, directors, and other actors for the company paying a large amount of money to the government, hundreds of millions of dollars in some instances, to resolve a case. They wanted repose, and now you don't get that release in a False Claims Act.
I mean, there's such leverage that in any government contract case or healthcare case, most healthcare companies get, the bulk, if not almost all of it, if it's a hospital company, almost all of their revenue from, or a large percentage of their revenue from the government. There's just incredible leverage that the government has and over the company. And while, back in 1996, I was one of the main lawyers that back then companies still hired firms my size to represent Columbia HCA in that huge investigation. And, we had joint defense agreements and, no individual got charged. The company ultimately, after 4 or 5 years paid, a large amount of money and the case went away. Today, the ability that the government has to almost, I'll use it's a strong word, but almost extort a resolution out of a company is just incredible, because to not reach a resolution, the company, a healthcare company, risks being excluded up front, even before they're charged with regard to their reimbursements. And so with the Yates memo, with the corporate sentencing guidelines and all that, what healthcare companies are doing now in these big investigations is, they're doing pretty much what Ron says, as far as, having these teams of people, doing all kinds of forensic, evaluations, but they are doing their best to reach a dollar resolution. And what happens is that the executives, many of them become former executives, they're pretty much thrown under the bus. And, most of these, on the civil side, in most of the cases I've been involved in, they're not just being done out of the U.S. Attorney's Office. There's usually a DOJ civil person that is assigned to the case, and they ensure now that there are no releases for individuals. I mean, there are just no releases, and it makes no difference in many of these cases when you go to the DOJ and say, look, my client is broke. He doesn't have anything. What is the purpose of this? Why would you, why would you waste the time to sue him? And you get a response pretty much like, what Sally, apparently believed, which, well, we need that for deterrent purposes. And, the fact that the person got fired, the fact that the person has, been subject to, his life's been turned upside, his or her life has been turned upside down, that seems like a lot of deterrence to me. But that's the practicality of what's going on.
I will say that again, I think when you look back at the genesis of the Yates memo out of the financial crisis, that a lot of people were very critical of the department for these executives who were, and bank executives who were moving from one bank to another, having done maybe fraudulent things, made a lot of money, and then just moved on, even if they got fired. And I do think that that's part of the decoupling civil responsibility for individuals from money to basically being tagged. You have done something that you can't pay for, but you're not going to continue to be in the field.
And there does seem to be a real effort on the part of HHS and the Department of Justice to coordinate in healthcare fraud cases and to impose exclusion remedies. In the Complementary Support Services case in Minnesota just a few months ago, both of the key officers involved in the alleged fraud in that case were excluded, one for 8 years, another for 5. They had to pay individual fines in that case. And then more recently, just a couple of months ago, in the Foundation Health Solutions case, which was a $20 million settlement relating to rehab therapy, they made one of the owners of the business co-sign the corporate integrity agreement and undertake individual compliance obligations under the CIA. So the department and HHS sort of working together to make sure that individuals are accountable not only in the criminal prosecution instances or False Claims Act resolutions, but also in the administrative sanctions that go along with enforcement.
So I looked. So we were looking to see how could you have an individual in the CIA with the company, and so I looked to see like what Sandy was saying. What are they going to make him do for the next 5 years? Like not do anything bad?
I think what I said, does he have to go to church or something?
Yeah. Or do something good.
Or do something good.
So that I looked to see, and he's not mentioned very often, but it is noteworthy that he is mentioned. And he was an owner, so some of it had to do with not being able to make money off of the sale of, or being monitored on the sale of his shares.
Right, and those obligations only would sort of sunset if he left ownership. But
Right.
as long as he was an owner of the business, he was basically bound to the same obligations as the company.
I mean, truthfully, in the Middle District of Florida, there's been such an emphasis on the civil side. I mean, we have lots of healthcare and defense government contractors down there, but they're so proud of, I mean, every time there is a matter, they're looking for dollars. So, it's interesting. The Yates memo, I don't think has really had that much effect on the criminal side, but on the civil side, it's had a huge effect. And in every case now, they're going after not just the corporations, but the individuals. And a number of these cases end up in no prosecutions, but they're judgments against the individuals. Usually settlements with the companies, and then they'll end up, filing a suit against the individuals and collect what they can. They're very aggressive in their collections. In a case that wasn't a healthcare case, an export control case, there was a $400,000 obligation that one of our clients had, and he still had a job and was, could pay it off, and they, sought to foreclose on his house, that he had owned for 20 years, and he wasn't that sophisticated. And when he originally purchased the house, he didn't put his wife's name on it. They've been married for 20 years. They have like 4 kids. And I went to the U.S. attorney. I went, what are you guys doing? I mean, he can pay this off over a period of time, but that was their policy. They're trying to get every dime that they can get.
Yeah. So in these large cases, and even though perhaps the numbers of white collar cases has declined, as the last panel mentioned, there have been huge ones. I mean, Volkswagen was huge, Takata very large. There have been other large healthcare cases as well. After the individual accountability policy was announced, and the obligation to provide to the government for any cooperation credit all relevant facts. The policy was also clear that, just as the department made clear when Larry Thompson was in the department, that waivers of privileges are not required, and that the policy doesn't require anyone or any company to give up their rights under the attorney-client privilege in order to gain cooperation credit, but facts are not the same as privileges. So, which raises the question of what do you do with facts that are obtained solely through the interview of a company's officers and employees, and whether or not there's what to do with the assurances that counsel for an individual would want under the circumstances where their officer or employee was being interviewed in an internal corporate investigation with the individual accountability policy in force. In other words, are joint defense agreements viable with this large incentive? And if so, does a company's counsel need to think about the terms and conditions of a JDA if they're going to share information with individuals? While Ron is still trying to sort out who did what. I mean, this is an imperfect mess at the beginning in many cases, and people are just trying to figure out what happened. You'd like some cooperation from your workforce in trying to do that. Sandy, I know that, you've represented a lot of individuals in these things and the companies, right?
I mean, what happens is that there are not that many joint defense agreements. I mean, there's look, a lot of these cases, the people representing the company are typically friends. We've colleagues, we've been friends for a long time, and so, if you represent a target, there's a certain amount of, and you have a good relationship, there's a certain amount of cooperation, but there's not really true joint defense agreements in most of these cases. I mean, it depends on if it's a private company, then you would get a joint defense agreement, but so we don't really have joint defense agreements anymore in the investigation stage in a lot of these big investigations. They will not, companies will not enter into it for fear, even though the DOJ says, hey, we're not, we're not going to say you're not cooperating because you have a joint defense agreement or don't turn over privileged information. The concern is if you go to the Department of Justice and say, look, we'd really like to cooperate with you, but all this information that we have is privileged, there's a fear that the effect will be that you don't cooperate. But what happens is that the corporation, calls up a person who's your client and says, we want to interview you. If it's a person that has not been represented yet, I really think that it creates, from a corporation's point of view, some real ethical issues. But that's another story. And the executive will either be sophisticated enough to be concerned and say, I really need a lawyer, or not sophisticated and undergo an interview from corporate counsel, which is privileged to the corporation but not privileged to the individual. And if he is sophisticated enough to say he wants a lawyer, most lawyers, most of us in this room, will counsel the client if he really has some potential, exposure, that you cannot do that interview unless you are prepared to have that information turned over to the U.S. Attorney's Office, because in fact, that corporate counsel is really an adjunct to the U.S. Attorney's Office right now because he's doing their investigation for him. And a number of corporations, depending on how aggressive they are, if the executive will not cooperate, will terminate the executive. And so it's this Hobson's choice that the executive has. Do I cooperate and expose myself to the U.S. Attorney's Office, or and what typically will happen, they don't tell him everything, the company then says you weren't really straight with me and gets fired anyway, or do I not cooperate and get fired? And it really creates a major issue for those of us that represent executives.
Yeah, and does the prospect that you learned that the Middle East corporate representative has been downsizing their expenditures so that they fit under caps and controls within the company, do you have to build in the prospect that you learn that fact from an account provided by an employee orally as part of your internal review into your joint defense agreement if you have one?
Absolutely. If you have a joint defense agreement, I think that you have to look at what you're agreeing to on both sides. So if you're the company, you have to be putting in there to draft that thing to say, if we learn something pursuant to this joint defense agreement, we're protecting ourselves, the company, and we're going to disclose facts that are otherwise, well, the facts aren't privileged, so we're going to be disclosing relevant facts to the government. So, and if you're on the other side, then you're going to have to, as Sandy said, be aware of that.
Well, you never sign that agreement. I mean, unless somebody explained to me what a relevant fact from an interview with my client is, if that's not...
I would say all facts. I mean, that if I'm representing an individual, I would assume all facts will be turned over.
Well, then that's not a joint defense agreement to the extent that it has to do with an employee interview.
Long live the joint defense agreement.
Right, if it has to do with an employee interview. I mean, it's tricky.
Right.
But many times, I mean, what happens is the government comes in and says, I want all your interviews.
Yep.
And you either have memos or you don't have memos. The memos are work product, but oftentimes the company will waive the work product as it relates to, they'll try to get some sort of a waiver agreement with the government about that. And or if they don't waive the work product, they'll sit down literally in a room and characterize orally what the contents of the interview was.
But, if you have the individual, Sandy, you still might be able to see documents that would help you defend
Right.
your client, and there are benefits to it.
To a joint defense agreement, but not to the interview.
Right, to that part, if there's a caveat, which I think Leslie Caldwell, after the policy was announced, suggested, was that people ought to be thinking about building their JDA if
Yeah.
you're going to have one with the policy in mind.
But you're right, Mitch, that there's still a lot of value to sort of circling the wagons and having a cohesive defense strategy and knowing what everybody is doing.
Ron, this all puts identifying sort of who the key players are up front in critical focus. So what are you seeing in the way of internal investigations that, as far as how they've reacted to the department's policy? And as a practical matter, how do you do your job differently to sort of make sure that the company has the information as soon as possible so that they can take advantage of the policy?
Yeah, and we were talking about that earlier with respect to this is something that you plan for right from the beginning of the investigation. And look, there's lots of investigations that we all do that there's no merit, and therefore there's really no one to run down with respect to culpability. But to the extent that the minute there becomes evidence where there's merit to the allegations or that we're seeing some behavior that is warranted further investigation, we, in conjunction, obviously, with outside counsel, run it to ground and are expected to run it to ground to figure out who all is involved in this particular scheme or who even knew about the scheme. They don't even have to be involved in the scheme. Who had knowledge of it? And sometimes we have situations. We had a matter about a year and a half ago where there were some suspicious transactions that were being investigated that were problematic to the company, that were approved by superiors outside of the country, that when we interviewed them, they, certainly approved them and they don't deny it, but they really pretty much said in the interview that they really didn't sort of dig into it. They didn't know all the facts around it, and it was almost like a perfunctory type of approval. Well, what do you do with something like that? I mean, obviously we wouldn't characterize it as people who were conspiring or were part of the actual scheme. In fact, there was no evidence to that extent. But now you have managers or supervisors who are pretty much saying that they fell asleep at the wheel. And how do you sort of deal with those facts?
Yeah, so I mean, the antitrust cases, if you have a price-fixing case, is a good example of why it's important to get to this first, because there the DOJ has approved the leniency policy. Individuals can escape prosecution under that policy, so it's a sort of a safe harbor from the general policy of the Yates memo. But you need to satisfy the leniency policy's requirements, which means, among other things, you have to be first in as a company, and it has to be a corporate act, and the government not aware of it, et cetera. So early identification, getting to the bottom of those things is critical, and then the officers benefit as well as the company.